SJC-13407, Russell Metcalf, and another v. BSC Group, Inc., and all.
Okay, Attorney LaSalle, whenever you're ready.
Thank you, Madam Chief Justice, and may it please the Court. Although the substance of this case focuses on the fairness of wages that are paid to hardworking laborers, at a structural level, it raises a very simple question. May an employer and an agency craft a contract that exempts them from a law that is meant to constrain them? This Court's faced that question in other contexts, and each time it has answered no. It should do so again here for three reasons. First, the prevailing wage
I don't know if that's really the right question. I mean, the prevailing wage law, you know, it's designed, you've got these public bids on these public construction projects, right? You don't want to have the non-union companies losing out the union companies losing out each time because they pay their laborers less than the non-union companies. So you create this wage scale to even the playing field so that low bid contracts don't always go to non-union contractors. This is totally different. This is a procurement services, a services contract, not for a particular public bid, but for surveying services on multiple projects. No one's going to lose out because they're union or non-union on this. It's a quality issue, and you set the prices separately. So I don't even look at this as we're dealing with apples and oranges here.
So, Your Honor, the Prevailing Wage Act is intended to protect employees' interest in a fair wage.
It's meant to protect public bidding contracts on construction to level the playing field.
Construction projects.
Projects.
Correct. And what we have here are two laborers who worked for 4.5 years on 36 construction projects. We know that from the description of the work that they performed from MassDOT's own witness. We know that from the language of the contract. If you look at the 2012 contract at JA 223, it says that it is to support the construction phase of bridge and roadway projects across the state of Massachusetts. So on its plain terms, the statute applies to the work that these laborers perform. And that is actually the correct inquiry is, does the Prevailing Wage Act apply? We answer that by looking at the work performed and not the words of the contract.
That's the problem, is the work performed. It's not specific to one project, which is a problem for you. The statute provides for the request for proposals to come first, and then you negotiate the compensation later, which is inconsistent with the prevailing wage law. It's for professional services. You do for quality assessment, not for labor, and the compensation is not some schedule of the prevailing wage law. It's the agency taking a look at what is the appropriate pay based on an assessment of the professionals. So you're dealing with, I guess I would quote Justice Kafka, apples and oranges. This just isn't a prevailing wage project. This is a contract for professional services, and the statute, 7C, includes such professional services include construction phase services.
Your Honor, it does say that in Section 58, but there's a very important limiting word. When we look at Section 58 and the portion that you just alluded to, it refers to related professional services, which means related to what? And when you look at
surveying, you need to do land surveying, mapping.
Yes, Your Honor. If those services are related to architectural or engineering services, if you look to the title of Section 58 itself, it tells you that it's procurement of architectural, engineering, and related services. So we would agree, and we wouldn't be here if the work performed were land surveying work performed to support the design phase of a public works construction project. But based on this record, we cannot say that that's an undisputed fact. In this case, there are facts from which a jury could reach the conclusion that the work performed on some or all of the sites was construction work. Now, 58, the purpose of that statute.
There was a contractor on those, right? I mean, he's working, your client is working alongside people who are part of the bidding process for that project, right?
Correct, Your Honor.
Those, it's not like we're excluding all surveyors from the prevailing wage laws. We're just saying when we bid the contract, you know, the guys working for those contractors are doing that. But this is like the DOT's group of, who are sort of working alongside them, but they're doing a different, they're serving a different function. They weren't part of the bid. They're part of DOT's, you know, professional team that works alongside that. It just seems to me different.
You know, Your Honor, I think there are some disputes of fact about that. But you did hit on a very interesting point that I think is important to recognize, which is that DOT could have bid this out as part of the construction contracts. And in fact, sometimes it did. There's evidence in the record from Paul Tivnan, one of the supervisors at Mass DOT, at JA 606 to 609, where he even admits that sometimes that contractor, the construction contractor, did have their own surveyors on the site, and Mr. Metcalf and Mr. Thur did their work for them instead. In other words, individuals who were meant to be paid the prevailing wage sat on the bench while two people were paid a third of what they were to do the same work. So I think from this factual record, it's too difficult to say that it is undisputed that the work here.
But the contract that we're talking about said that there would be crews to provide surveys for roads and bridges, and then it said, as needed. That's not one project, public project, that we think of when we think about the prevailing wage law. To provide survey for roads and bridges as needed, survey crews as needed.
Yes, Your Honor, and two things to know about that. First, the place where they are deployed, where Mr. Metcalf and Mr. Thur were deployed, was on construction sites. You know, to the extent any of their work may have been deployed to a design phase project or to post-construction work, then we would agree that that would not be prevailing wage eligible. But where in this contract some of the work that was actually performed is construction work, that work should receive the prevailing wage. So it's conceivable, Your Honor, that you could have a contract that covers as-needed services. And some of those services are on a construction site, and some of those services are on a pre-construction site. Under those circumstances, the Prevailing Wage Act requires that we pay the prevailing wage for prevailing wage eligible work. The other thing I would note—
Can I shift you to a couple of issues? The language, we included this language about strict liability in a couple of our decisions. Was that just dicta? Was that in, does the legislation itself say it's a strict liability statute, or is there anything in the legislative history? It's odd terminology to appear in a labor statute as opposed to a tort statute.
It does appear in a few of the legislative enactments involving labor, but the way that the strict liability regime is imposed in this case—
No, but again, we use the word strict liability. I understand that. The SJC did that.
Correct.
Was that based on anything in the statute, or did we just characterize this as a strict liability statute?
It's based on the fact that the statute says that whoever shall pay less, in unequivocal words, whoever shall pay less than the prevailing wage so established shall be liable.
That's the basis of strict liability?
I believe so, Your Honor. And that's important language, because what that does is it turns the employer into an efficient enforcer of the Prevailing Wage Act. When you think about how these contracts are negotiated, you have an agency or a municipality on one side of the table and an employer on the other. The employees, the people who are entitled to the protections of this act, don't have a seat at the table. And so to ensure that their interests are protected, imposing strict liability on an employer aligns that employer's incentives.
So even though here the actual public entity, the Department of Transportation, doesn't think it's a prevailing wage contract, doesn't include the prevailing wage requirements, and the company, which is not bidding on, again, a public construction project, but on a services contract, should know that it's prevailing wages and should pay those prevailing wages even though they have no idea what they are? It just seems like that's punishing when the state government doesn't even think it's a prevailing wage contract?
Not at all, Your Honor. I think that there's two important factors to keep in mind here. First, as Your Honor noted, we know from the red briefs in this case that DOT made the decision on its own that the prevailing wage shouldn't apply. But the statute is clear. That's not DOT's decision to make. If the work to be performed touches a public works project, you must ask DLS. DLS makes determinations of whether it applies or not.
Did you ask DLS? I'm going to ask your brother whether DLS has weighed in here. But did your clients ask DLS also? So DLS is like strangely absent here.
I would agree that it's strange to see DLS absent. You'd think that the easiest way to resolve this would have been if DLS had issued a determination early on in the case. I'm not really sure what we should infer from the fact that we're now at the SJC and we still haven't heard from them. But I will note that employees, this court has explained in the past, do not have the authority to go to DLS and ask for a wage determination. But we know from the record that DOT can, and in fact must, and we know that employers can. If you look in the record at JA 478 to 80,
so you're forbidden from asking? I understand you say they have an obligation, but also we had litigation. Did anyone seek to depose them or anything? No.
Your Honor, I was not trial counsel, but to my knowledge, there's nothing in the record indicating that anyone sought to depose someone from DLS.
Yeah, okay.
Instead, the court can and should be guided by DLS's prior determinations in the context of field engineers.
Those are pretty, and he's going to get up and distinguish that, and it's pretty far removed from this, but go ahead.
Under the DLS opinions that have issued in the past, starting with CAT through the ICF Kaiser decisions into the 2011 decision, DLS has been consistent that the way that you determine whether prevailing wage applies is you look at the type of work and the phase that the public works project is in. If it's design phase, then the prevailing wage does not apply. That we know from CAT. But if it's construction phase and it's work that is done in aid of construction, then that prevailing wage would apply. Now, I want to go back and I want to acknowledge something else Your Honor said, which is that it may feel counterintuitive to hold an employer liable. And I can see that perspective. The challenge is that that's how the statute is written. The statute imposes liability on whoever fails.
Certainly not how it's been interpreted by the District Court of Appeals, whatever it's called, all the federal courts. The McGrath decisions ruled the exact opposite. So we would be overruling that, which we can, of course, but it's going certainly against a lot of the case law out there, except for this recent appeals court decision, which distinguishes 27 from 27F, which is an interesting distinction.
The court can and should actually overrule McGrath and its progeny because the core flaw that led the Superior Court astray here also led the court in McGrath and those that followed McGrath astray. And the issue is the strict liability regime applies regardless of the intent, regardless of why an employer failed to pay. And we know that because as the Superior Court held earlier in the case,
that's a different issue. I guess once it is determined that the Prevailing Wage Act controls, then the employer is liable, maybe, even if, is it DLS?
yes,
Doesn't issue a schedule. My question is, when do we determine when the Prevailing Wage Act applies? You say it's if it touches construction during the construction phase. Why is that the test?
So if I understand Your Honor's question, it's when do we decide whether to ask about the prevailing wage?
No, when does it apply?
It applies if the work that employees, laborers, apprentices, et cetera, are performing is construction work. There's nothing in Section 27 that conditions its applicability on the words of a contract or on it.
So here, they say it's consulting work, and it was, not bid by project. It was instead the request for proposal was related to the qualifications of the various vendors who were vying for this, not based on total cost of the project.
Correct, Your Honor, but
Why is that not the test?
as the court noted in Tomei, one of the cases that BSC cites, nothing in Section 27 requires that the bidding process be a low bid basis for the prevailing wage to apply. And that's because it turns on the type of work done. They also noted that nothing in the Prevailing Wage Act requires a specific citation to a specific rule. And that's why the citation of Section 58 in the later of the two contracts doesn't carry as much water as I think it appears it might from the red briefs.
But couldn't you have two surveyors? The Commonwealth may want its own surveyor as well as the contractor, because we don't want the contractor to go build on places that he or she is not supposed to build, right? So we're going to have our own surveyor double checking and making sure people stay within their bounds. We don't want somebody who works for the construction company making those calls. So even though they're both working at the same place, they may be performing different functions. One's checking to make sure you don't go build the building in the wrong place, right?
I think so, and you could have those circumstances. I think the challenge here is that there are factual disputes that would preclude us from saying definitively that it is undisputed that the work that Mr. Metcalf and Mr. Thurr were doing was construction, was quality assurance work. If, for example, the only sites that they worked on were post-construction, right, or design phase, then sure, the prevailing wage wouldn't apply to that work. But as BSC noted in its summary judgment brief, in this case, on these facts, it is a fact-intensive inquiry as to which work the plaintiffs performed that should garner the prevailing wage. And with those disputes, summary judgment should not have entered, but for the error of placing dispositive weight on the language of the contracts instead of looking to...
Right, we do get to that other issue, which I mean, donus only matters if 7C doesn't answer the question. And then we have to figure out what are the implications, as you referenced, of the no schedule. And I guess what I'd say is, why isn't donus distinguishable? That is 27F, dealing with a specific type of rental equipment, vehicles. And we've got a long line of cases now. Admittedly, the seminal case is an appellate division case, but there's so many cases from the United States District Court for the District of Massachusetts. They just didn't cite to the case in the appellate division. They did the work and analyzed it and said that it matters and there's no obligation if it's not included.
So, Your Honor, I hear a couple of things in that question to address. The first is the line of cases. And what's interesting is, we've talked about the appellate division case a couple times, that really got the ball rolling. Because when you look at every case, that's cited in support of the rule that the language of the contract should trump the work actually performed, all of them cite back to McGrath, with the exception of, I think, one, which cites to Bronsky, which cites to McGrath. So it really all flows from that one single case, which, again, like I said, it ignores the key role that the strict liability regime plays in the statute, which is ensuring that somebody at the negotiating table has interests aligned with the employees and is thus incentivized to ask, hey, DOT, do you think that that we should ask about a prevailing wage, or incentivized, as we see at JA 478, to go ask DLS themselves, or as we see in Andrews and Kennedy, to pay the prevailing wage on prevailing wage eligible work, even if the contract is silent on it. There are a number of ways to ensure that the interests of laborers in a fair wage is protected in this process, but none of them can function if an employer is not held strictly liable. And to allow an employer to avoid liability or responsibility for a Prevailing Wage Act violation, that even if it didn't cause, it has the opportunity to remedy or prevent, would leave laborers with no remedy. Because as we know in this case, they can't sue the DOT because of sovereign immunity. And so what we have is, an admission that the amount paid was 1/3 of the prevailing wage, and yet no means by which laborers could vindicate those rights unless they were hired before and were sitting around and literally monitoring their boss's contracting process. And it can't be that the legislature created a statute that contains a remedy, and yet there's no means of accessing that remedy. And so in a case like this, where there is a colorable dispute of fact as to what work was actually performed, whether it was construction, whether it was quality assurance, whether it was pre-construction or design phase work, that's a question that goes to the jury. Was this prevailing wage eligible work? And if so, were they paid properly for it? The Superior Court, by jumping straight to the language of the contract, shortchanged that entire process. And so on that ground alone, this case should go back down to follow the proper standard that's set out in Section 27.
Okay. Thank you very much.
Thank you, Your Honor.
Attorney Burwood.
Is it the work done or the words of the contract?
Good afternoon, Your Honor. May it please the court. Jonathan Burwood for the defendants, BSC Group, and David Hayes. Justice Loy, I appreciate the question, and it follows up on a question that Justice Wendland asked earlier. So what the plaintiffs offer to the court is that it's the work done, okay? They say that the trigger for prevailing wage is what work is being done. That is not what the statute says, Your Honor, okay? 149, Section 27, the third sentence talks about the fact that the start of the application, when is the application of the prevailing wage determined? It's determined prior to the contract being let, okay? Section 27 requires that prior to awarding a contract for the construction of public works, the agency shall submit to the Commissioner of the Department of Labor a list of jobs, and then it shall request that the Commissioner determine the prevailing wage. The statute then goes on to talk about the fact that the agency, in this case MassDOT, once that the prevailing wage has been determined, that prevailing wage schedule be included in the bid solicitation. All of this happens before the contract, okay? That is pursuant to the terms of the statute, but it also serves a particularly practical end, which is that the amount of wage being paid, the rate of wage being paid, is one of the most significant drivers of a cost of a construction project. And so all of the participants in the construction ecosystem on these public works jobs need to understand, is this a prevailing wage job or is it not? It will set those costs. That is particularly true given the prevailing wage applies to contracts for the construction of public works. Because contracts for the construction of public works, Your Honor, are publicly bid. They're low bid work. So in order to qualify for an award of that work, a construction contractor must submit the bid, and that bid must reflect the cost of their job. So both the terms of the statute and just the practicalities of how these jobs are let require that the determination, Justice Lowy, about whether or not the Prevailing Wage Act apply be made at the outset. It cannot. It would violate the terms of the statute, and it would be impractical to enforce. It cannot be the case that a couple years down the road, you've got hundreds of people working on this project in the field. They're performing thousands of different tasks. Determining whether or not the prevailing wage applies based on any of those individual tasks being done by any individual person in that job, it's not a workable solution. It wouldn't provide the certainty, it wouldn't allow parties to get...
You have to monitor every professional that you, or consultant you ever had to make sure that they weren't touching the shovel the wrong way?
Yeah, it certainly would, in my words, or I'd say it would create a free-for-all. And I think that's one of the things here that needs to be avoided. And the plaintiffs suggest that that should be the rule, that any work being done on any public works project needs to be scrutinized at any given moment. That is not practical, but most importantly...
I agree with you on that point, but that doesn't really answer the question whether this kind of contract would still be subject to the prevailing wage laws, right? Because DOT has all these public bid contracts. It can't just sort of carve out work that would otherwise be in that contract and avoid the prevailing wage law. I mean, they can't say, okay, I'm going to make all the truck drivers or whatever, I'm going to cut out all the truck drivers and put them over in here. I don't know if that answers the question. I look at this as a different kind of contract, but I don't think it necessarily removes these contracts from the prevailing wage if DOT is trying to carve things out of things that would otherwise be bid in the contract, right?
So, Your Honor, again, with the statutory framework being that prevailing wage applies only to contracts for the construction of public works.
Right, but this is a contract for work that's going to be performed on public works, right?
It is, Your Honor.
And it's a contract for work that's going to be performed on public construction works. But I get it's different, but it's not so obvious that it's, to me, it's complicated. And I guess one question is, has the Department of whatever it's called, DLS, what's their name?
Yes, Your Honor.
They're not
DLS.
Here. Is there anything in the record indicating what their position is on this fight?
Your Honor, I'm not aware of anything in the record. To my knowledge, DLS didn't weigh in on this, and what I would say is that's reflective of the fact that the Mass DOT, the Department of Labor Standards, that this project isn't a secret. These contracts aren't secret. There's testimony in the record that these professional services contracts are routinely let by MassDOT pursuant to 7C Section 58. The fact that they didn't weigh in indicates that this is not a contract for the construction of public works, therefore the prevailing wage
But how do we
does
know
not
they're
apply.
aware of we know they're aware of these things? I mean, I have just no idea.
Your Honor, I suppose it's possible the statute actually requires the agency to request a schedule from DLS, so there is an argument to be made that if the schedule is not requested, how do they know? Right. It's not in the record before us, but if I could answer a second part of your question, it's not the case that MassDOT can simply carve certain public construction activities away from the Prevailing Wage Act. Right. How do we know this is not a contract for the construction of public works, I think is the way I'd reframe that question. And I've cited to Section 27 and the indicia there. What I'll also say is that in Massachusetts, public works project on roads and bridges are let pursuant to Chapter 30, Section 39M. Right. And Chapter 30, Section 39M has very specific requirements about certain provisions, content that must be in those contracts. One example would be unforeseen site conditions. Another would be if the owner suspends work. There's additional statutory language in Chapter 39 that informs the content of a public construction project for this type of job. When you look in the record at the two BSC contracts, those contracts are so clearly not consistent with Section 3039M, that's another sort of touch point in terms of identifying how they're different. And then third, to that point, on their terms, they refer to the fact that they're for consulting services. The second contract actually says it's let pursuant to 7C Section 58 because the statute was passed between the two contracts. But the other thing is that there's language in the contract itself that talks about the fact that that BSC is going to be providing this field survey work for the implementation of the construction component. The plain reading of that contract indicates that there is this work being done by BSC essentially to support MassDOT so that the construction work can happen. And then lastly, Your Honor, I'd say, though not a part of the record, as you pointed out earlier, every single one of these projects that we're talking about, there was a Section 3039M contract that a general contractor issued a bid for. It was publicly let, and that contract is governed by the Prevailing Wage Act. There is a distinction made in Section 27 where some contracts are prevailing wage and some are not. And we'd offer to you that for all the evidence in the record and all the arguments made, that these contracts are simply not subject to Section 27. They are not contracts for the construction of public works. Your Honor, the last point I want to make is just that...
Can I ask about the strict liability language that we put in? Is there anything in the statutes, that call it a strict liability statute, or was this just something we added at, because it is odd language.
Your Honor, I agree with Attorney LaSalle that, to my knowledge, that the strict liability language is not in the statute. It's judicial interpretation.
Okay.
But on that point, I guess what I'd say is that there's a tremendous amount about strict liability in the plaintiff's briefs. And my reaction to that, both in our briefs and here, is strict liability simply means if you violate the statute, your reason for violating it does not matter. You're liable. What plaintiffs assume, and what I think I want to get across very clearly, is that the statute must apply in the first place in order for strict liability.
I think we understand that. It's just, our question is, okay, so if we ruled against you on the first point, McGrath would still rule in favor of you on the second point. And that's where the strict liability stuff becomes meaningful, because your reason would be that you didn't get the bid. I mean, you didn't get the list of wages, but if it's a strict liability statute, that goes out the window, doesn't it?
This is not a technicality case, Your Honor. I think what you're getting at is BSC is not taking the position that because they didn't get the wage, it's not applicable.
Well, I'm trying to figure out whether you win on which issues if you win on. And to me, the strict liability thing complicates McGrath. If this is a strict liability statute, McGrath may not have been correctly decided, but I'm not sure it's a strict liability statute. So that's why I was focused on that.
The additional way that BSC looks at that also, Your Honor, is that the requirement in Section 27 that MassDOT, in this case, that they issue a prevailing wage schedule, that's an indicia about whether or not this is a prevailing wage contract. The fact that they didn't indicates, again, that it is not. And the McGrath, and as I understand it, the courts that have interpreted it, the appellate division of the lower appellate division, the superior court, state court, those courts have essentially said the requirement of Section 27 to be prevailing wage eligible, MassDOT must issue this schedule. If it does not, this contract is not prevailing wage eligible. I don't think that's the only argument here, Your Honor, but it is certainly the one focused on by the trial court.
So I want to focus on what happens if you lose for a second. If you could cogently tell me why contractual indemnification and unjust enrichment would apply as to your cross-claim.
Given my time, Your Honor, I'll focus on the better argument, which would be the unjust enrichment, okay? So here, we've got a contract with MassDOT. MassDOT and BSC agree to a certain rate of wage. MassDOT ultimately pays that rate of wage, and BSC pays that rate of wage to the plaintiffs in this case, okay? If, in fact, it is determined by Your Honors that the prevailing wage should have been paid, there's no rationale for BSC. We are the middleman. We are simply passing the money, the wage rate from MassDOT to the employees. The unjust enrichment would be evident in the fact that if BSC, my client, is forced to pay the enhanced rate of prevailing wage and cannot recover that money from its contracting partner, MassDOT, there's a restitution interest that is not met there. They simply did not bargain for having any independent exposure to the plaintiffs. We simply agreed to offer these services at the rate agreed to by MassDOT, keeping in mind that MassDOT determined initially this is not a prevailing rate job. It was not our determination. And under unjust enrichment, Your Honor, the restitution interest to BSC would guarantee that somehow MassDOT would not be unjustly enriched, but more importantly, that BSC would be made whole here.
Okay, thank you.
If there are no further questions, thank you, Your Honor.
And Attorney Isley.
Good afternoon, Your Honors, and may it please the Court. Kate Isley, Assistant Attorney General, on behalf of MassDOT. The BSC contracts, as Your Honors have noted, were for professional services and governed, in our view, by Chapter 7C, Section 58.
Even though one of them predated 58?
And prior to the enactment of Section 58, the longstanding distinction that has been made by the DLS that distinguishes construction contracts from services contracts.
Is that the 1995 one you were referring
It is the Central Artery opinion that from 1995, but also the Lancome letter opinions that the appellants have cited to. Those are.
We can find them.
Yeah, they're in the record. I don't have it right here, but in the language where the Lancome and the Central Artery opinions specifically apply to land surveyors, and in the Lancome opinion letter, it says that land surveyors shall be paid the prevailing wage if they are working under a construction contract. And in this case, these land surveyors were working under a services contract to provide quality assurance, on-site survey expertise for MassDOT over a number of years in District 3 on various highway and bridge projects.
What do you say about the contention that that may well be, but it's a factual issue?
I would disagree that it's a factual issue. Both Section 27 and Section 58 have in their language references to contracts. Section 27 relates to general contractors in putting the prevailing wage schedule onto the contract. It is all tied to the construction contract and the construction particular project. I would also point Your Honor's attention to Section 27, the carve-out that the legislature made for all persons who transport gravel and fill to a job site. And for those persons, where the language is all persons, and it says all persons shall be paid the prevailing wage, no matter whether they're under the construction contract, an independent contract, the owner-operated contract. So I would submit that the legislature knew how to carve out an exception to whether a laborer is an employee of the contractor or the general contractor.
So what about the concern that you got the agency who doesn't want to pay the prevailing wage because it'll save money? You got the employer who's going to make more money if they're not paying the prevailing wage, and they're negotiating a contract, and the victim is the employee.
Well, I would point Your Honors to the landscape of the statutes, and that there are guardrails on these statutes. And if you look at the bidding, the way that these types of contracts are bid, you can see that in Section 58 contracts, the MassDOT cannot even consider price until after it awards a contract on qualifications. And that reflects a legislative priority that MassDOT should really be looking for quality firms. Whereas under Chapter 27, it's low bid. And of course, the prevailing wage would apply to a low bid because contractors might seek to lower their bid to win the contract on the backs of the workers. So that reflects another legislative priority. Now, MassDOT bids construction contracts pursuant to Section 27 on a regular basis, and pays and seeks the prevailing wage schedule, and it's incorporated into the construction contract. This is just not that case. This is MassDOT also. I'll point you to.
What? I guess I thought Justice Lowy's concern was, what if MassDOT and the standards agency, I'm not saying that this is this case, but what if they collude and say, hey, we don't want to pay the prevailing wage, we just want to get around that law, and so we're just going to call it a Section 58 contract? What is it, what's preventing, other than, everybody's good faith and
Well, so
from
professional,
doing that?
the professional services, Section 58 only applies to 6 types of professional services. It's architects,
There's another
engineers, land surveyors, landscape architecture, environmental science, planning and program management, and the individuals employed by those 6 types of professions. And then the work that the professional services work must be logically related to the work that those types of professionals do. And Section 58 also explicitly provides that land surveying is one of those professional services, and land surveying specifically during construction phases of MassDOT's projects is explicitly provided in Section 58. So if we're looking at contracts after the enactment of Section 58, MassDOT would be permitted to bid these contracts pursuant to that statute. Prior to Section 58, MassDOT still had a basis under DLS guidance and also Section 27, because under Section 27, that is clearly applicable to construction contracts. And the facts in this case just do not support any collusion, and it's conceivable.
I'm not suggesting
it's
it's
conceivable that could happen.
Yeah,
but-
and so given that conceptual possibility, what is stopping this? Because that is, I think, essentially what the claim is here. There's nothing to stop MassDOT and the contracting agency or the vendor from colluding to avoid the Prevailing Wage Act.
Well, I can say that Section 28 has been enacted in law for 10 years, and MassDOT has
58?
58,
Okay.
sorry, 58, has been enacted since 2013, and MassDOT has been bidding its professional services contracts the same way since then and prior to then. And if I can point you to the John Anthony affidavit, who is
Can I ask one other, are you representing the Department of Labor Services on this? Are they joined in this brief in any way, or?
they are not.
And can we count on not getting a future case where DLS takes the opposite position? Or have they not been consulted on this?
They are not involved in this case, but based on the distinctions DLS has made in their opinions, I think it's consistent with MassDOT's long time practice.
They're not aware of this brief, and we've not gotten a letter or anything indicating that DLS supports this interpretation, right?
One way or the other, no.
Zero,